Thank you for the folks who are joining us. This is probably, I do a lot of different types of seminars and webinars, and some of them are interesting. Some of them are fun to do, especially if I have somebody that I'm presenting with that I enjoy a little bit of back and forth banter. If there's a particular hot topic in the news or something that a lot of folks are concerned with, we did something on the non-competes and the coming changes to non-compete law a few months ago, the Medicare payments and audits and recoupments are becoming a hotter and hotter issue, especially as now Medicaid and private companies are moving into that field. We're going to do some more stuff on that later this year. But this seminar that we're doing now for healthcare businesses, I was thinking about this, and may perhaps be the most valuable, I think, to the average business owner or somebody running any type of business, really, but especially there's some particular risks in healthcare, and we'll talk about that as we go through. If every business owner looked at this material every 6 to 12 months, I wonder how much risk we would reduce, and particularly lawsuits and demands and claims and so forth. So we're going to walk through it. Here's the agenda. Pretty easy, basically talking about timeline of really resolving disputes. First, how do we do it from the beginning? How do you keep things from blowing up to start with? The setup, both in your personal, how your personal assets are held, and especially for professionals and those who are subject to potential for lawsuits, physicians and other professionals, how the business is structured and how you can reduce risk and liability there. We'll talk about business operations. When something, when a claim starts, when a dispute starts, how we handle that, what are the action steps we need to take, what are the things we need to be aware of, and then we'll talk about lawsuits themselves and trying to get those things resolved in the best way possible. The best lawsuit is the one that you're never in. So starting from the beginning, as the slide says here, sometimes if you are operating a business in the U.S., and I'm here in Florida, Florida is a litigation hotbed. Sometimes litigation is unavoidable, and if you find yourself in litigation, or you have to initiate some type of relief through the legal system, or if you get sued, some of the steps that we talk about today will be helpful for you in planning to succeed. Start with the end in mind. So when you're setting up your business, first thing is you want to make sure that if you're a business owner, you're involved in a business, you want to make sure that your personal liability is limited as much as possible. And you also want to make sure that if you have a valuable business, that any other claims that might come, people think about the first part and think, okay, if I create a corporation, or I create a limited liability company or some other limited liability entity, the business takes on the brunt of the liability and the individual is protected. That is true. That the main exception to that is if you personally sign documents, agreements, guarantees, or if you sign those documents personally, or if you sign personal guarantees for those things. And that's very common. If you go and seek traditional financing for anything, for equipment financing, to purchase a building, for business startup capital, you are going to be required, if you are the business owner, or if you are affiliated with the business in some major capacity, you may be asked or required to sign a personal guarantee. That's going to be almost unavoidable. Another place where I see a lot of guarantees, where you really need to be careful, is in factoring arrangements. In healthcare, services are provided, and sometimes payment is delayed depending on your relationship with the payer and who the payers are. And more I'm seeing companies that are factoring their receivables so that they can keep cash flow coming in on a regular basis, but that factoring arrangement comes with a trade-off. Typically, there's a high cost to do that, and the factoring companies will ask for personal guarantees, and they'll tell you, well, this isn't a loan, and the factoring arrangements are treated. For anybody who doesn't know what that is, essentially you sell your future receivables for cash today. But really it is a loan. It's a loan based on the receivables, and they treat it that way. And if for some reason you sell the future receivables or you sign an agreement to sell the future receivables and the factoring company who purchased those and provided cash doesn't get paid from those receivables, whether it's because you went out of business or for some other reason, they will often look to a personal guarantor to collect. So it walks and talks like a loan. If that agreement is subject to Florida law or some other states, there's some potential there that it could be treated as a loan, which has implications for the legal defense, particularly with respect to usury laws and so forth. But most of those agreements are governed by the law of a state that is much more favorable for the factoring companies. New York is very common. So in any event, when you're signing any documents, look and see if you're signing on behalf of the company or on behalf of the business. Flip side, for protecting your interest in a business, let's say you have real estate, that you have your business operation, you have a medical clinic and it operates out of real estate. You may own that building. You obviously, and I say obviously, but it's not so obvious. I have had clients who have a business, XYZ, let's call it XYZ medical clinic or dentist office or something to that effect. And that same company then buys the real estate and owns the real estate. Well, if the business gets sued or if the business doesn't make it, if for some reason the business doesn't have sufficient cash coming in, you now risk losing the building and the business. If the business gets sued in particular, a giant claim against the business hits the building. So you want to keep those in separate entities, separate legal entities. Another issue is you could have a very valuable asset in a business, and if you don't have that ownership structured properly, you could have a personal claim against you, whether it's a professional claim for liability, malpractice, errors and omissions, or some type of claim in that fashion, or just a simple garden variety car accident where you have a demand against you for $500,000 or $1 million or more from one of the billboard lawyers. And they'll look to your insurance, but if you don't have high insurance coverages or enough insurance coverage, or even now sometimes with higher insurance coverages, we're seeing where the driver or the owner of the vehicle, you don't have to be driving in Florida if you're the owner or the driver. In a lot of states, this is the rule. Anybody who has an ownership interest in the vehicle can get sued, and then they'll ask you, what assets do you own? If you own a business, if you own a successful medical practice, X-ray clinic or MRI clinic or lab clinic, and you own that business, or you own the real estate in which it operates, or both, and you own it in a corporation or in a single member LLC, or a general partnership that hasn't been properly registered, those business assets can be subject to the personal claim. So it's very important in the beginning to make sure this stuff is set up correctly. A lot of people try to go it alone. Do a lot of reading on it, at least consult with a lawyer on it, and get somebody who knows what they're doing from a business perspective. And the last bullet point on here on this slide says separation equals insulation. And that's where we talk about keeping your different business interests in separate silos, essentially, to keep those protected so that a claim in one doesn't adversely affect the other. Agreements and contracts. I have talks with clients a lot about contracts. Here's my philosophy on contracts, and this has been developed over several years of practice, both in drafting, negotiating, and litigating over contracts. Contracts are a lot like fences. And if you live in a good neighborhood and you've got reasonable neighbors and you put a fence up, that fence defines your property line. As a general rule, most reasonable people stay on their side of the fence. If they want to cross onto the other side, they ask permission, or maybe they're invited. There's certain reasons to cross over or to not treat the fence as a hard boundary. Maybe you put a gate there and that tells people where they come in and out. If you have a contract with another party, that contract is a lot like a fence. The contract provides your guidelines. It gives people an idea of where the boundary lines are. But if you do business with a scumbag, and I see this often, if you do business with a scumbag that's got no business integrity, no personal integrity, they will try to take advantage of the contract. They will, people, just like somebody can hop over a fence, sneak under a fence or around the fence, burn the fence down, chop the fence down when you're not looking, knock the fence down, do all other kinds of things to get around the fence. People will do that with a contract. Sure, the contract has rights and remedies and dispute resolution procedures and things you can do, but criminals will find ways to engage in criminal or quasi-criminal behavior. And so if you do business with somebody and they're just a crappy business partner, and sometimes you pick things up from the beginning. So often clients will tell me, oh, in my gut, I felt this, or I kind of knew there was a problem there. One thing that we'll do sometimes with some of my clients, if we're entering into a big business deal, we may just run a background check. I've done that a couple times just recently where things just didn't seem right. And I have an investigator that I work with, and we'll run a basic background check on a company or on individuals involved with a company. We'll just see if they've been involved in lawsuits. Recently, I was doing something like this with a client, and this name popped up. 3 or 4 lawsuits around the country, all within the last 2 to 3 years. All of them had some element of fraud in it or fraud allegations. Look, innocent until proven guilty applies in the criminal courts. In the civil courts, people on both sides typically have some merit to their position. But if you are doing business with somebody and they've been in a half a dozen lawsuits over the last 4, 5, 6 years, you got to ask why. Why can't they get? And it doesn't matter if they're a defendant or a plaintiff. You got to ask why. Why is this party getting into so many disputes? That's one red flag. Another red flag I will give you is that if you get a contract from somebody, or if you get terms and conditions or a standard document, standard form from somebody, and it is totally and completely and absolutely one-sided, you need to take a step back and again, determine, is this somebody you want to do business with? Why is the contract so one-sided? It doesn't mean don't do business with them. And this comes up, I just had something like this happen recently. Longtime client, we got some standard terms from somebody, and as I was going through the document to mark it up, I just about halfway through, I shot him an email and we jumped on the phone. I said, this is completely ridiculous. Some of the provisions they have in here. What's driving this? Why do they have a document that looks like this? Is this the way they're trying to do business, that they want to get every edge over on you? Or is it maybe the other direction? Maybe they're not very sophisticated and they pulled the document off the internet and they thought it was great. Or maybe they had their lawyer draft it and the lawyer is, maybe the lawyer approaches law that way. I don't think that's necessarily the best way to approach law. When I draft contracts for clients, most clients want the contracting process to be pretty smooth. But sometimes young, aggressive lawyers will do that. Sometimes older lawyers that were just taught that you try and get every advantage you get over on the other side. So 2 things to look out for. 1, what kind of party are you doing business with? And 2, what does the initial document, when you're contracting with these folks, what does that initial document look like? Pardon me. And if you have any questions along the way as we're going through this, feel free to shoot them over to me. If you have any interesting situations, again, this is a seminar that I've done before. I like covering this material, but I am happy to address questions throughout if they pop up. So slide here has key points, common errors and misconceptions. Timing is key. And what we mean by this is, especially with the way a structure is set up, if you, let's take the situation. This comes from a real life, most of this stuff comes from real life situations that I've seen over the last 20 years. You have, I'm going to change the businesses and the names, but I have a dentist office that runs their business, and then they enter an agreement to purchase real estate, and the agreement goes sideways. Or let's say they own the real estate in the business. Let's use a different example. You own the real estate in the business, but then they have some other type of claim that potentially arises where maybe somebody's going to threatens to sue them for malpractice. It's too late to change the business structure to move the real estate out of the business. You needed to do that ahead of time. Just like individuals, if you get sued and after you get sued, you decide that now's a good time to set up a self-settled asset protection trust. Once you've been sued, it's usually too late. The time to structure things properly and to protect yourself, especially if you're going to go into business and you're going to get involved in something that's a higher risk business or in a regulated industry like healthcare, make sure that your personal house is in order. If you have significant assets, make sure that those assets are held or titled or have some degree of protection around them. There's statutory protections potentially. There's ways to hold assets in limited liability entities, in potentially used trusts, and other titling mechanisms for husband and wife in Florida. Simple way to own bank accounts that are in regular personal accounts. If you hold it as a tenants by entireties account, you protect your if one spouse is in a high risk situation, that spouse, their interest in that marital account is not subject to claims of their creditors and people who make demands on them. In those situations, then you want to avoid having the spouse ever sign personal guarantees. I'll see that that's very common in franchise type arrangements. There's a recent healthcare group, a healthcare franchise I've been looking at for a few folks in Florida, which is interesting because it's a regulated industry, but this is a national group that sells these franchises. And in some circumstances, they send a franchise document. They want the spouses to sign the franchise document, sign personal guarantees. There's some issues with that. I'm usually very resistant to that. I don't want spouses who are not involved in the operation of a business to sign agreements, sign contracts, because it just creates additional avenue of exposure, additional avenue for potential collection by the party on the other side if they do have a claim to go after you. So we try to avoid that. Also here on the slide, structural control and protection or versus protection. Sometimes, it's especially in a personal context, when we talk about asset protection for individuals, we do a lot of this for, again, for professionals, for physicians and other folks that are high income earners. When you're setting up structures and asset protection, sometimes more protection, you have to give up some control, and there's some trade-offs there. So there's a fine line to walk. You can't necessarily drop everything into a trust and keep it entirely protected and maintain control. The flip side, or the trade-off of that, is if anyone tells you that you can put assets in some type of structure, in particular, I think of trusts, you can put them in a trust, but if you need to make any changes, if you need to do things down the line and make it different, that you have that flexibility to do that. Well, that's probably not going to work for asset protection purposes. And the reason why is that, as a general rule, if it's treated as a revocable trust, it provides no asset protection benefit whatsoever. And if you have the right to make changes or modifications to the trust, then what happens if the day comes that you're in court or you're subject to a court order that requires you to make modifications to this trust document so that you can make arrangements to pay a creditor who's asking the court to make this modification? Well, if you have the authority or the ability to do it in the document, a court can compel you to do it under threat of contempt. But if you have no authority or ability to do it, a court is not likely to put you under a contempt order by ordering you to do something, you refusing to do something which you have no authority to do under the documents. Finally, it's a good idea to have a team. Whenever I meet new clients, I ask them who else they're working with. Whenever I meet potential clients, first thing I'll usually ask is who they're working with for accounting and tax purposes. If they have a relationship, especially in healthcare, relationship with an insurance broker, advisor, somebody on the financial side, a banking relationship, but especially accounting, insurance, potentially maybe consulting for credentialing and for licensing and other things of that nature, where it's maybe not the most cost efficient to have your attorneys working on that things, but somebody that we can rely on or somebody that we can look to run with those issues. And then legal, and understand also as well that with law, one size does not fit all. Somebody who is very skilled in business issues and healthcare issues potentially may have no knowledge, like me, I have no knowledge of criminal law or of issues that might come up in your personal, in family. I have very little exposure in that area. People who do criminal law probably don't have expertise in healthcare law. People who do estate planning and trusts and probate work may not be the best people to consult with for tax issues or for corporate issues. So understand that one size doesn't fit all. That's for a lot of different professionals. So have a team, have people that you can call and ask questions of routinely. And I appreciate when my clients call me and ask me for an introduction or referral to someone else, some other lawyer who can help them with a specific issue. And I am happy to facilitate those relationships. So moving into operation of the business, obviously, when we're talking about healthcare and insurance and third-party payers, there's a lot of compliance issues. It's a good idea to have policies and procedures in place before you are operating the business, but also before any claims arise, so that if there is something where you're asked in litigation, it's not uncommon for a company to ask, what are your policies for handling this? What are your policies for handling employee complaints, for instance, employee harassment? What are your policies for building relationships with new vendors? How are those folks vetted? What if you have a HIPAA issue and you're dealing with somebody where you're exchanging confidential information, or you're giving somebody technical access to your system? Do you have a procedure in place for protecting confidential records and documents? It's a good idea to have these policies in place. Oftentimes there's HR groups and there's folks, you don't necessarily need to go to a lawyer. There's folks who have some of this, but if you have a policy, if you have a disaster preparedness and response plan, if you have a data breach plan, I've prepared these for clients. Read it, take a look at the plan so you at least know what's in it, and make sure you understand it. You don't have to pull it out every day, but make sure you read it. So if you ever do have to use this, one, you're familiar with it, you know what you have. Two, you can identify ahead of time if there's things on there that aren't clear or things that you don't understand. And then it also just gives you a good guidepost for handling crisis situations. I also suggested anybody who has employees have a good employee handbook, something that you can turn to when there's questions about how to deal with certain employee issues. On note of the employee handbook, something that I like to do is have employees specifically acknowledge the confidentiality provisions that'll be stated in the handbook, even if you don't have employment agreements with your employees, but have them acknowledge anything that might, in particular, survive their employment with your company. So confidentiality is one of those issues, obviously. When somebody's working with you, they are required to keep patient data confidential. After they stop working for you, just because they're no longer your employee does not mean that that obligation should not continue. And so it's a good idea to have those folks sign something in an acknowledgement or some type of document. I like to use an acknowledgement with an employment handbook where they specifically acknowledge that the confidential information related to the business will stay confidential, and they won't share that even post-employment, after they're finished employment with the company. More on operations. Yeah, I mentioned earlier audits, audit responses, record responses, in response to audit requests, providing records, documenting the fact that you provided records. We're seeing this more and more from, Medicare has been doing this for a while. We see prepayment reviews and post-payment reviews and recoupments from Medicare. We're dealing with a few of those right now. If you get stuck in that loop and you don't respond properly, you could have a situation where there's a small review for a limited period of time. You don't provide sufficient records, you blow it off, you pass it off to somebody else, and they don't respond properly. Now, whoever's doing that review, the Medicare contractor looks at it and says, well, we didn't get appropriate records, so we're going to deny these claims. They deny some claims, and maybe it's a $5,000 hit, and it's not good, but it's $5,000, and maybe it would have cost you $2,000 to deal with the record response. So you're like, okay, whatever. Well, that $5,000 claim can then trigger, because of the error rate, can trigger further review. You could even find yourself subject to a Medicare suspension and under investigation for fraud allegations related to Medicare payments, and see your entire practice essentially on the line because of not providing a proper response. I've seen this happen in connection with where the contractor said they didn't receive the records timely, where the contractor said they didn't receive the proper records, where the contractor said that the records were not accompanied by the proper attestation, where the contractor, or I say contractor, but I've seen these with private insurance as well, under Medicaid, managed care, and under private insurance companies, where they've said that the records were improper because the physician referrals were not properly signed, because there wasn't proper documentation to support the claims. All of these are an issue. I've also seen where they've said that they didn't provide a timely response. One circumstance that I was personally involved in, that was I don't remember the exact details, but it had something to do with a 20-day response time frame, and it was 20 days from the date of the letter from which the response was due. but it took the letter, according to the date of the letter was dated and it did not arrive, it was not received until 12 days later. Whether that was because the letter wasn't actually mailed that day or whether it's because it took that long in the mail, but then the response going back, according to the date that the contractor said the response was received, the response was received 9 days later. And it just so happens in that case, the company had the card, the signature card, the certified mail receipt and the mail card that went out that showed the date that it went in the mail. They could show that it took 9 days. Well, if you've got a 20-day from the date of the letter response, and it takes 12 days to go one direction and 9 days to go back, you're already at 21. And so under those circumstances, a contractor was saying that a response was untimely because it wasn't received within 20 days from the date of the letter. Obviously, and this is a contractor, oftentimes they have PO boxes, so you can't use FedEx or UPS. You can use postal priority mail, but if you mail something and you've got 5 days even to respond, you figure the mail's going to get there on time. So something as simple as that. If that wasn't documented, if they didn't have the certified mail receipt showing when the mail went out, if they didn't have a system for documenting when the mail comes in and what day that this is received, this could create problems. And instead, it creates protections for you when you properly document this. Record keeping, and also when you send, I'm going to harp on this issue a little bit more. When you send an audit response or you're responding to any type of request for records and information, it is a excellent idea to include a cover letter that lists everything that you're enclosing, and it invites the recipient to contact you if they did not receive everything, if everything is not complete, or there are any problems with the transmittal or with the receipt. This goes for whether you send it by regular mail, email, or fax, or any other form. You want to have an enclosure that lists what you're sending, and that's for your own record keeping processes. And for the other side, it tells them what you're sending and invites them to contact you if everything wasn't received. That way, if a month later, 3 months later, you get some type of response that says you never responded, or you didn't fully respond, or you didn't properly respond, you can turn back to that communication, to that document. Maybe it's just a enclosure, table of contents, here's what's enclosed. But you can turn back to that and say, now, when we sent it, here's everything that we said was enclosed, and this is the correspondence that went to you as the recipient, insurance company or somebody else, auditor, and we said at the time, if everything's not in there, let us know. And if we didn't get a response from you, we can only assume that everything was in there. Had we gotten a response, we could have corrected it at the time. Of course, this all presumes that you're enclosing with that the information that you say you're enclosing. We're not advocating that you try and pull one over on somebody by not enclosing that stuff, but you certainly want to include a list of everything that you're sending. I want to do a webinar or a seminar walking through a contract so that the average business manager or contract representative really has a better familiarity of what the legal implications are of certain contract provisions. So here I've just put a list on a slide just to look at your agreements, understand in particular timeframes. I always recommend to clients, if you have a date for, oftentimes you'll see something that says, this contract will automatically renew on X date unless you give notice so many days before. Go Outlook, you can do it now, Google Calendar, Apple Calendar, whatever calendaring system you use, put a calendar date on there right away. Even if it's a year out, 5 years out, 2 years out, if it's every year, put the date on there, have a recurring date, then give yourself the leave time in advance so that if you want to give notice not to renew the agreement, that pops up. You can always ignore it, but put that on your calendar that date, and then give yourself a reminder a little bit of time in advance that that date's coming up. So you're going to have generally 3 dates for these types of deadlines. I recommend you have somebody do that at the time you are entering into any agreement, any timelines that are important. Put those on your calendar, and that will help you avoid missing deadlines later. Boilerplate. I get this comment a lot from clients. They say, well, that's just boilerplate. Boilerplate can actually become important when it covers things like what the governing law is on a contract. Earlier, I mentioned factoring agreements. The law in New York and the law in Florida is substantially different on how factoring agreements are treated, so much so that you may be able to enforce one under New York law, even if it's with a Florida party in Florida. You can enforce one under New York law that may not be enforceable under Florida law. Non-competes are that way. A lot of physicians, physician assistants, nurses will be asked to sign non-compete agreements. In one circumstance, it was a multi-state provider. This was actually great for a client of mine that signed an agreement that had a non-compete provision in there. I think the contract was governed by New Jersey law, and New Jersey is not nearly as stringent on enforcing non-competes as Florida. So that gave us an out, because the contract, that the employer in that circumstance made the determination, the business decision, to have New Jersey law apply, and in doing so actually invalidated their ability to enforce the non-compete. So the boilerplate stuff, yes, it's boilerplate, but it can change and it can become important under certain circumstances. Your dispute resolution procedures, which I'll talk about in a few minutes, are particularly important. And I often suggest that people modify those, and I'll tell you how in just a moment. Your definition section of a contract, if the contract does have definitions in it, anytime you're reading a contract, if you see capitalized words, this is where you're going to find any capitalized word probably has somewhere in it a definition of what that word means. So don't assume by reading a word that you know what the meaning is. If it's capitalized, if it's bolded, if it's underlined, if it's used repeatedly in a contract, if you are reading a contract, this actually is also for statutes and rules, but if you're looking at a contract and you're coming across a word and you're not sure exactly what that word means, search the beginning, the end, the definition section, or somewhere in the body of the contract, and try and find that word and see what it means. It's very easy to do that now with a PDF document. You can OCR the document so you can make it searchable, and just search the word and find it and see the first use of the word. Usually the first time it's used is going to be where the definition is, or towards the beginning or end of the contract. This is some stuff that you can just make notes of for operating your business or your practice. Always having somebody to report to, having a person in charge of specific issues. What if something goes wrong? What if a patient has a problem or a question? What if somebody from the insurance company calls and has a question? Who's in charge? Who do people ultimately look to make decisions? Have somebody that's always in charge on the premises. If you are, and I've done a separate seminar on the obligations of medical directors. If you are a medical director in Florida, you can be a medical director for multiple facilities, and a lot of physicians will do this. And it can be a good gig. You'll serve as a medical director for different clinics. With that role comes specific responsibilities that are outlined in the statutes and in the rule, where you're obligated to make sure, as a medical director, for instance, that all the billing procedures are proper. You're obligated to make sure that the proper signage, identifying you as a medical director and identifying other key points, is posted in the clinic. You're responsible for making sure that patient records are properly maintained and protected. There's certain responsibilities that you have, even if they're not in your medical director agreement. You have those responsibilities. And so as the medical director, if you're getting into a relationship like that, you want to make sure that you know who the day-to-day person is in charge. Who's the person that you can turn to that is going to be responsible for taking care of these items if you're not immediately available, if you're not on site or on the premises at a particular time. If you refer out, this is good practice for anything, but especially in healthcare. If you make a referral to another professional or to another office, it's a good idea to follow up with the referral, because what you don't want to have happen is that something goes wrong and then the patient blames you or blames your practice, and then wants to drag you into that and say, well, you sent me over there, you pointed me in that direction, and now you've become a target of the problem. Simply, it's a little bit of bedside manner, I suppose. It's simply getting ahead of those issues by following up with patients. Hey, we referred you to so-and-so. How was it? Did everything work out okay? Do you need us to look at something else? Those little things, they're the little types of things, the communication that you can have with patients that could create big problems later. Obviously, don't guarantee results. Recently, actually, I had a client that told me, made some comment to the effect of, it's a relatively new client. Well, you told us there was a lawsuit. You told us this was a slam dunk, or you told us this was guaranteed. And I reminded them and told them I did not tell you. I know that I did not tell you that because never in 20 years of practice have I told anyone that any lawsuit is a sure thing or a slam dunk, because they're not. It's just not true. It doesn't matter what the circumstances are. There's always risk associated with any type of lawsuit or adversarial proceeding, whether even in arbitration or in an administrative capacity. Uh, recognize problem clients and patients. Somebody said to me years ago, we never regret the client that we turn down or turn away or don't take. Um, you're not always in a situation with patients where you can turn them away, but I have had circumstances with clients. I have one client who's got a very unique practice, and they had, since COVID, they've had a hard time with a few patients. They have patients who travel to see them from all over the country because of the uniqueness of what they do. And the patients got used to doing check-ins by Zoom, and the client was able to accommodate them. Obviously, there were also some exceptions. The laws were relaxed during the COVID period in 2020 because people weren't able to travel and everybody was on restrictions, and people were at home or not leaving whatever their premises or place was. But then as things got back to normal, the client wanted people to start coming back in on a regular basis. And there's issues with folks who are coming from other states to get treatment in Florida, because if you're routinely using telehealth to treat a patient in another state and they haven't come to you, as a general rule, the law very well may look at that as saying you need to be licensed in that particular state. If you're a physician and you're providing telehealth services for a patient in Maine, and that patient, you've never seen that patient personally, and all you've ever done is treat them by telehealth, well, then you very well may need to be licensed in Maine to provide services to that patient. Florida would say that you need to be licensed in the state where the patient resides or where the patient is when you're seeing the patient or treating the patient. Medicare, up until COVID, at least generally looked at things the same way. If the patient travels to you, if somebody travels from Maine or from some other part of the country and they travel to your office in Florida or Nevada or somewhere else, then the patient has made that choice to come see you and you treat them and you're licensed to provide that care. Now there's a question about your follow-up care. Well, is the follow-up care, do you have to be licensed in that state to do follow-up care with the patient? Well, I don't think that's generally the rule, that you have to be licensed just to do follow-ups. But at what point have you gone from just doing a follow-up to maintaining a relationship and maintaining care where that patient needs to come back? If the patients are resistant to that and they start to get nasty about it, maybe it's just a good idea to sever that relationship. Especially if you're just an elective provider for them, especially if you're not in an insurance network or anything else, and it's just a cash pay business, and you've got this patient now that's complaining and becoming a problem just because you're asking them to follow some basic procedures that are designed to protect everybody. Maybe it's a good idea to just move on from the patient. Avoid those types of things. Avoid risky behavior. Comments. Social media is terrible now with comments and negative comments. Please try to refrain from that, and have your staff and employees and other folks also refrain from it. Now we'll move on to talking about disputes and threats. I've listed here some of the types of disputes that can arise. One thing you have to understand from the beginning is, what's the regime under which you're going to resolve these disputes? You have disputes with employees, for instance, then it's an internal issue, generally speaking, unless the employee goes and makes a complaint somewhere. Most of those you can control with very good proactive behavior. I have several clients who will contact me on a regular basis. They have an issue with an employee. We're trying to get in front of it. A lot of that is just understanding. It's avoiding a misunderstanding with the employee, trying to address any problems that arise before they happen. And if you have something that looks like it's going to blow up, getting very far ahead of that. Employee issues can be a debacle for businesses. And a lot of them, I do believe, can be avoided with some good proactive behavior in advance. If you're dealing with payers, if you're in the Medicare regime, then you have the Code of Federal Regulations and the whole payment system that exists under Medicare or under Medicaid in some circumstances. Medicaid, you'll find that in your state statutes, generally speaking. Florida, you'll find it in the administrative code, that's rulemaking. It's done by the Agency for Healthcare Administration, by ACA. If you're dealing with managed care, you'll have a managed care contract. Those managed care contracts will often refer to and incorporate other handbooks and other policies that you may go to their website or somewhere else that could be routinely updated. If you are dealing with, if you're in the hospital setting, you're going to have bylaws, and you're going to have a whole regime in the hospital to deal with peer review and that system. You have a right to a fair hearing for complaints that arise. You need to understand, you have a copy of those bylaws, understand what the hearing process is, what your rights are under that process, either yourself or you need to get legal counsel to help guide you through this. Another thing to consider is when disputes do arise, one of the things that should pop into your head is not only should I be handling this myself or go it alone, but do I have insurance coverage potentially for this? Licensing complaints, you might have insurance coverage for that. Some policies have riders. Pardon me. Some policies will have riders for covering license issues. Payment audits. There's policies. We do some work where the insurance companies provided coverage for payment audits. You may have coverage there. So keep that in mind as well. Oftentimes when people reach out and contact me, that's one of the first things. As a matter of fact, something came in last night with a client of mine, and first thing we did was send it over to the client, and then said, contact the insurance carrier and find out how they want to handle this, or find out if there is coverage. I was pretty sure there was with this issue, and let's get them involved right away so they can get insurance counsel appointed. You can still have your own personal counsel, or you can have business counsel work with the insurance counsel. I do that on a regular basis. But if you got somebody else that's going to foot most of that bill, take advantage of that in your policies. When you're responding to legal threats, you get a demand, you get somebody threatening you with a legal issue. Now it's a good idea to get somebody involved. Be very, very careful in your responses. So many times I have seen clients send stuff out that we look at and say, gosh, I wish you wouldn't have sent that. Or I wish you wouldn't have phrased it that way. As soon as there's an issue that pops up and this thing could blow up, we want to be very, very careful about how we're responding to letters, how we're responding to demands, what we're putting into writing, what information we're disclosing, and why we're disclosing that information. And then also, if there's certain time frames, I mentioned earlier, again, the payment audits thing is really on my head because I'm just seeing so many of them. If you get a request for records, if you're under audit from an insurance payer, there's going to be specific time frames for your response. And you need to make sure that you calendar those timeframes and get ahead of it. Don't wait until the last minute. I just spoke to a potential new client that I just spoke to him for the first time on Friday, and we had a follow-up call yesterday. And it turns out that a letter came in July, and the response is due next week. It's a 60-day, 65-day response. Don't wait that long. It's going to really put you up against the wall. You might be able to get an extension. You might not. That's something else to look at. If you get something late, maybe you want to get communication out right away. If you think you're going to be untimely with a response to something, send a response that it asks for additional time, maybe explaining the circumstances or not, and just say, we've got this, we're on top of it, we need more time to respond. Most times you can get additional time to respond to things, including lawsuits. If you get sued and you're trying to get insurance counsel involved, ask for additional time in a lawsuit. Most of the times the plaintiff or whoever represents the plaintiff will grant you that additional time. And I'll tell you, as a simple matter of experience, if you ask for additional time and the plaintiff doesn't give you more time and tries to default you in a lawsuit for not responding in time, and you are diligently trying to seek counsel or get representation and deal with the issue and respond, and you file an untimely response, I think in those circumstances, oftentimes a judge is not going to look kindly on the plaintiff who did not grant you your request for additional time. They're going to say, why didn't you do this? And then they're going to lift the default and allow you to respond and deal with the lawsuit as you need to. Here's a little checklist for preparing. If you do receive a demand right away, you want to identify your facts and witnesses, figure out who the team is that's going to deal with this, both internally and outside, and then start doing a bullet list or a chronology of events. And really, this is as soon as you see something starting to blow up, you want to start keeping a chronology, keep notes of what's been happening. There's certain circumstances where you may want to confirm conversations and things that happen in emails or other communication to your counterpart. Not necessarily taking positions all the time, especially without a good team, without really thinking it through, but at least confirm what the communication is. And then also, here's another big one that a lot of lay folks don't quite understand the implications of. That's privileges that apply to communication. Give you a simple example is that, let's say we have a question about the value of something, the value of a particular claim, or the value of some particular measure of damages. If the client obtains an appraisal or obtains a valuation report, that's going to be discoverable in litigation. You're going to have to turn it over. But if the client, if I get that as the attorney and I hire a consultant, as the attorney, I hire a consultant to create that same report, I can protect that report as work product under the work product privilege and may not have to disclose that information to the other side, unless, of course, later we designate that person as an expert. So there's a lot of times that we can do things internally as lawyers, and there's privilege that applies to that doesn't apply to you as the client. So talk about that with your legal counsel. There's other privileges that apply that I've listed here, but that's the big one that you're going to see is anytime you're getting information, professional advice or information from somebody, there might be a privilege that applies to it, and understand that. Some more just general advice, and I want to make sure I hit on a couple of points at the end, so I'm going to probably move a little bit faster through some of these slides. But some of this is pretty, attack issues, not people. But be wary of admissions and careful with concessions. This is all just as you're dealing with disputes, you really want to say, oftentimes you want to get in front of stuff, but you don't want to start making a bunch of admissions. Oh, we were wrong. We could have handled that better. Especially if it looks like something that's going to turn into a lawsuit, you really want to be very judicious with your communication, and maybe decide if you want to make most of it verbal. Maybe you want to you want to have a settlement conference, but you want to do it under confidential mediation rules. So as Tony mentioned in the beginning, I'm a certified mediator. When I do mediations, the big rule in mediation is everything is confidential. The idea is we're trying to facilitate a settlement between parties that are in dispute, whether they're in a lawsuit or pre-litigation or wherever phase they're in. But you want people to be able to talk without the worry that whatever the information they share is not going to be used against them in court. So mediation has strict rules surrounding the mediation. Say whatever happens in the mediation stays there, and you can't talk about it outside of that. Well, in settlement conferences, and when I'm dealing with clients and other issues, I will often I'll request, if I'm trying to share information with the other side or with their attorney in particular, they'll understand what I'm talking about. I'll say, look, we're willing to share some information with you, but we want your assurances that you're going to keep this confidential, and we want this all to be deemed confidential settlement communications. So it can't be used against us if it doesn't help facilitate the settlement. And most reasonably minded folks will agree to that. The threats that I talked about here, the government agencies and these are the ones to be aware of. If you get a letter from the licensing body, or if you get a subpoena, or if you get a request for records, you really should be contacting your insurance broker, your attorney. You should have somebody you can talk to that's familiar with these issues to help with the response. You should be doing this right away. Be calendaring when the responses are due, and making sure that you're gathering information and responding fully to these requests. I see so many times where people could have avoided problems just by making sure the records were complete from the beginning, or that they documented providing records. I also see issues with inquiries, license inquiries, where people did not provide information or did not respond, and the issue blows up a lot more than it needs to be. I had a physician in that circumstance where, for whatever reason, did not respond to just some basic inquiries, but it ended up becoming a threat on his license. And once you fall into that hole, things can be a lot worse. Other advantages to using the lawyer or as an intermediary in communication. Very easy for me if somebody puts me on the spot in negotiations, if I'm representing a client or if I'm the mediator, to say, I don't know, I'll go check with the other side. I'll go find out an answer for you. Or for me to take a hard line position, say, look, we just can't agree to that. I can't let my client agree to that. That happened recently when I was negotiating these terms and conditions that I referred to earlier. We just can't. These are way over the top. Not something that we would ever agree to. Where can we find some room in the middle? If you're the client, if you're a physician and you own your own medical practice, or you're a partner of practice and you're negotiating with someone else, if let's say a patient has a complaint and asks a question about something, or a vendor or somebody else asks a question, you say, well, I don't know. I have to go find out the answer. And you're there, the question, then the next question is, well, why don't you know? You're there every day. You're involved in the business. How can you not know the answer to that question? What, are you not properly supervising everybody? What's going on over there? When you're the lawyer, you don't have that situation. You can just say, I don't know, or I'm not, let me talk to my client before I get, let me get back to you on that. We do that all the time, even if we think we know the answer, because it gives us time to go back and sort of make sure that we have the exact answer in the form that we want it, that's accurate, honest, but conveys the right message that we want to convey as well. I'm going to do a whole separate webinar on payer audits and responding to payer audits and the different levels of the response. I've done one before, but I'm going to go into a little bit more detail. I'll probably bring in one of the folks in the office here that works on these as well. We may do it as a tandem, and talk about the different levels of appeal, what the forms look like, what the time frame is for sending, what kind of information you want to include. But as a general rule, you want to follow the rules. You want to understand what rules you're dealing with. Most of the time with payer audits, if it's private insurance or Medicare, the letter that you get should have some instructions on how to respond and the time frames and what that response should look like, but it's not always obvious. For instance, with audit responses, and you have certain forms and there's form numbers that attach to those, they don't always include that information. Sometimes you can call and get it. But there's very specific ways that you need to respond to these. I'm going to do a whole seminar. Hopefully people will be interested in that. I mentioned insurance coverage earlier. If you always want to check and see if you have coverage to help you deal with some of these legal threats. Common errors and misconceptions. Here I put in the last page on this. Always from the beginning, figure out what your end game is going to be. That's really the issue but that's both if you have a claim or if you are on the opposite side of a claim. Try and figure out what is the end game. Where's the other side want to land? What's their interests? What are they trying to accomplish? And where do you want to land? Figure out where you want to land. Figure out how you can get there, and then try and stay on course for that action. Often, there are very few cases end up going to trial or to a final hearing if it's administrative or arbitration. Oftentimes, things are resolved in advance. And it usually can be through some type of settlement or sometimes through some other type of resolution, like a summary judgment or a dismissal or some other issue. But very few disputes go the distance to a final determining body, whatever that is. So always keep open lines of communication and look for ways to try and get out of lawsuits. Finally, the lawsuit itself. Preservation of evidence is key. Don't throw anything away. Make sure that stuff gets preserved and turned over to your lawyer. You also want to make sure that the other side doesn't throw stuff away. And the lawyers in claims will send out a preservation letter to make sure that the other side doesn't get rid of or destroy information, which is subject to potential sanction by a court. And very early on, you want to identify who are the potential witnesses and try and get statements or get information from them early on. Another issue that I've seen come up a lot is I'll hear from a client that somebody who used to work with them, one of their vendors, a contractor, somebody they had a relationship with, has information, or we need them to sign something. I have another client, we needed somebody that was involved with the business to sign off on something that was just a technical issue. It would have made solving the problem that much easier if we could just get the right person to sign off on a document and that person wasn't around anymore. And it's because we didn't identify the person and the issue until much, much later when if we'd had all the information from the beginning, if we'd known that the person was involved. So right away, try and identify who are the people you need to have involved to resolve a claim or a demand, and communicate with those folks very early. I talked about insurance, also contractual indemnity. You might be involved in an agreement that says that if you get sued because of the actions of another party, very common, this might be in in an employment agreement with a hospital. If you're a physician working with a hospital and you get sued because of the actions of the hospital staff, you very likely have some indemnity language in your contract with the hospital, or you should have mutual indemnity language in there that says that if you get sued because of the actions of the hospital or its staff, the hospital is required to indemnify you. So regardless whether you have insurance coverage, they're required to pay for your defense, pay for any potential damages. Those indemnity provisions all look different. They all operate in different fashions, but you should identify very quickly. And if there is an indemnity provision, you should put them on notice. By not putting the other side or whoever's required to indemnify you on notice of the indemnity, you could waive it later, because the other side could say, well, we could have stepped in early and defended that. And by waiting and sitting on your rights, you've actually waived the protections that indemnity was required to provide for you. And I'm probably going to finish up here with this. Understand that in every dispute, there are at least 3 theories. And people will generally say, well, there's my side, there's the other sides, there's my version of events, there's the counterpart, I don't like to say the opponent, but the counterpart's version of the events, and then there's the truth. And in the legal world, that is not the case. I call this the 1% rule. You have your version of events, you have the other side's version of events. That version of events is presented to a court or to a determining body, a jury, a judge, arbitrators, whomever, administrative panel. That information is provided them in the form of evidence, witnesses and documents and so forth. That evidence is a smaller universe of what everybody knows. All facts don't come into evidence. Some stuff is hearsay, some stuff is rumor, some stuff can't be substantiated, some stuff is inadmissible for other reasons. So there's a smaller universe of information that comes into the discovery process and comes into the dispute process. That information, an even smaller portion of that, just the key pieces of what's important, what's strategically important, and what's admissible, will then come in as evidence in a case. And then you've got whoever's listening to the evidence, a judge or a jury or an arbitrator, and I do arbitrations, and I'll be in this position when I'm sitting as an arbitrator. You can't absorb everything. You absorb maybe a small percent. So maybe you have, of everything that comes in, of all the information in the world, the universe of information surrounding something, 10% of that gets into the trial. Only 10% of that information, at most, gets absorbed by whoever the arbiter is of the decision. Well, that gets you to 1% or less. Your dispute is going to be resolved on this very little bit of information out of the entire universe of facts, which may or may not be the key pieces that are helpful for you. And if you keep that in mind, then you understand why mediation and alternative dispute resolution is so beneficial, because if the parties to a dispute who are most deeply involved are able to work through their issues and get a resolution, that's generally going to be more favorable. You get to determine your own destiny and pick a result that you can live with. It's going to be more favorable to being in a lawsuit and having to deal with that mess and quagmire. I don't get to cover some of the key points and misconceptions, but you have the slides. If you have any questions, if there's any questions, anything that I didn't address while we were going through this, feel free to contact me afterwards. My contact information is on the screen. And I appreciate you joining us today, and have a great rest of your day. Bye-bye.